Hello, everyone. Drake here from Renti, coming to you from our new Auckland headquarters in Newmarket. We've got the post-Christmas beard going on, so no comments about that. This is not how I wanted to introduce the video, but unfortunately, on the day, my internet packed a sad. So today, I'm redoing it. So we've got Paul Holmes, Managing Director of Info by Design, one of New Zealand's foremost privacy experts. Info by Design helps small, medium, and large companies implement privacy policies. He's truly an absolute expert in the industry and has had a lot to do with property management over the years as well. And of course, Joe Ray, Senior Consultant of Residential Property Management to the Real Estate Institute of New Zealand. Needs no introduction herself. She's truly one of New Zealand's experts on property management, a whiz, an encyclopedia on all things property management. She's wonderful, and she's joining us as well. Hope you guys enjoy.
Thanks, Drake, and thanks for having me online today. So Info by Design, we're New Zealand's largest privacy consultancy company. We work across the country, working with organisations in a range of industries, including a number of large and small businesses in both real estate and property management. So the day-to-day challenges that each of you are dealing with in terms of running your business in the privacy space, we've got lots of real practical experience around that. And so some of the things that I'm going to be touching on today are based on those kind of real-life examples where we've had to help or advise property managers in relation to privacy matters. So I'll just bring up slides and we can get into it. And really wanted to start off by setting the scene around privacy and why it's important and what you need to think about. And the first thing to think about really is, what is personal information and how you should be approaching it. So the way that we look at it is that personal information is a Taonga, it's a treasure, it's something that's of value to an individual. And when you have access to it, so when you have access to either an owner or a landlord's personal information or a tenant or prospective tenant, it's because they've given permission for you to have access to that information in exchange for the services that you're providing. So you're really the guardian, the kaitiaki of that information, and you have a responsibility to make sure that it's cared for, protected, and respected appropriately. And the lens that we like to put on that is to think about your own information or that of your family and friends. How would you like your bank, your lawyer, your doctor or medical professional to be caring for your information? And when you're doing your day-to-day role, are you taking that same duty of care for the information that you have access to about the individuals that you're working with? And privacy is an interesting one in terms of, obviously, we have legislation around it. But the concept of privacy has been around for quite a while in different forms, in some cultures going back thousands of years. But in terms of the kind of Western legal framework around privacy, it really started with the invention of the Kodak portable camera, of all things. Because prior to that happening, photos used to be, you had the big tripod with the man behind the cloak, and you had to stand really still while the exposure happened. And with the invention of the portable camera, people being people, we had the first iteration of the paparazzi come out. So you had people hiding in bushes and taking photos of high society and sort of rich people's parties and things, and then publishing them on the broadsheets in places like London and New York the next day. And a couple of Harvard law professors got really upset about this and wrote an article called The Right to Privacy, arguing that people should have some level of protection over what others can do with information about them. And that's continued to evolve in terms of what it means sort of over time. Obviously, as technology changes, then the type of information that there is about people and where it's stored and how it's managed has continued to change. So if you think about New Zealand, we've had a Privacy Act in place under legislation since 1993. That was put in place before the first New Zealand hosted website existed. And personal information then was largely things in filing cabinets and Lundia systems in government agencies or in businesses. Versus if you look at what personal information is today, it's everywhere. It's all over the place. It's all over the world because it's stored in the cloud, and we're using so many different services from so many different countries. And 20 years down the track, it could be even more different. We just don't know where the technology is going to take us yet. And so the way that our privacy legislation kind of caters to that is it's principles based. So it's written to be technology agnostic. There's no real black and white rules in it, which is great because it means that it's continued to kind of be fit for purpose as technology has changed, social media has come out, cloud storage has come out, etc. But it makes it actually harder for businesses in a way to understand their obligations, because there are no black and white rules. There's principles that you have to understand and interpret in the context of your organization's operations, and then make sure that you're complying with it. And so fundamentally, privacy is all about personal information, but more so than that, about people having some level of agency or control over what other organizations and other people can do with their information. A couple of important points to note. It doesn't have to have a name on it to be personal information. So you can de-identify something by taking off someone's name, but it's still information about them. And given how much data is out there, it's still relatively easy to re-identify someone if the right processes are not taken in place. So don't think because you've taken someone's name off it, you've anonymized something. In our country, obviously, we have our Privacy Act, which was updated in 2020 with some rules. And particularly for the property management sector, the Commissioner has issued a couple of years ago now rental sector guidance due to, I guess, what they viewed as past poor practices within the industry and the impact on it. So the Privacy Act in New Zealand is a little bit different than in a number of other countries as well, where it applies to all businesses, big or small. Some of the other countries have it only apply to large organizations. And also for us, it actually applies to individuals. So if I do something wrong with someone's personal information, they can complain to the Privacy Commissioner about me as an individual. It's not only relating to businesses. So we just need to be mindful of that. And just the other point of note around the Privacy Act to keep in mind is the way the Privacy Act is written, it sits, I guess, subsidiary to all other legislation. So if something like the Residential Tenancies Act says you can do this, or you can't do this, or you must hold this information for a certain period of time, that takes precedence over the requirements in the Privacy Act. So the Privacy Act is really there to fill in all the gaps where it's not clear in legislation what you can or can't do. The Privacy Act sits there to help you understand and be informed on that. And so the compliance framework that the Commissioner's Office has released defines specific expectations for property managers and landlords, and also makes it a little bit clearer what tenants' rights are in relation to their information. There's a link there, or a URL there. It's on the Privacy Commissioner's website, privacy.org.nz. If you haven't read it or familiarize yourself with it, I urge you, as probably the big takeout of this, is to go away and do that, because it is something that they have an expectation that all property managers in the country and landlords should have an understanding of and be complying with as part of how they conduct their business. And it is actively monitored through both audits and mystery shopper visits. So you won't know necessarily when you're getting caught out for not following the rules. But if you do, they've got a number of sort of mechanisms for them. I think their initial step will be they'll send you a warning letter, say, hey, we've observed this, you need to change. They could, if they're really concerned about it or see repeat offences, launch a full investigation or audit under their powers, which you will have to comply with, and that will come with definitely a significant sort of overhead for you in terms of providing the information and engaging with that process. They have a tool under the Privacy Act called a compliance notice, which is a legal instrument that they can issue if they're not happy with your practices, which legally requires you to change what you are doing with personal information. And failure to comply with that can come with both a criminal conviction as well as a fine of up to 10,000 New Zealand dollars. 10,000 New Zealand dollars is, it'll hurt. It's not massive. But the other thing they can do is make public statements about you naming your agency, saying we have issued a fine for non-compliance against property management company X. And, that's the worst case scenario, because then you're in the media, and in an industry as competitive and, tightly managed as yours, that brand or reputational hit could take massive amounts of time to recover from. I think in terms of the general studies around privacy breaches in competitive environments or that sort of thing, about 40 to 50% of the cost associated with that is the brand impact and the lost business that results from it. And that can have a multi-year tail after it. So, don't think about $10,000 being, oh, well, that's not a penalty that we have to really worry about. We'll just figure our way through. The cost is going to be in terms of your brand reputation and the trust that people have with you. They can also, if they're really unhappy, refer you to the Director of the Human Rights Proceedings, which means that you may end up in front of the Human Rights Review Tribunal, who can award penalties of up to $375,000. So, hopefully no one would ever get to that point, but it is there as kind of, the worst case scenario if you do things really badly. So in terms of the compliance framework and just good practice, just a few things that you should really have or be thinking about if you don't have them. So having a privacy breach management process with clear roles and responsibilities. So if you do, have the issue where you accidentally send someone's information to the other thing, attach the wrong attachment, or have a complaint where you've over collected information, knowing who's responsible for it and what you're going to do and how you manage it is really key, so that you don't spend the first few days running around like headless chickens and you can just get on with it. People have the right to ask for a copy of their information or ask to it to be corrected. So having a process for how you manage those things, really important, and who's responsible for making decisions associated with it. Having clear guidance in place for staff on making sure that when you're doing inspections, you're being privacy compliant. One of the big areas where people get caught out all the time with that is photographs, capturing a whole heap of people's personal information and then storing those or using them. So that's again making sure that you're mindful of that. Having really good processes around consent, and that doesn't mean having a tick box on the application form that someone ticked once that therefore applies as consent forever. That means if you're doing something extra, ideally people should understand and be aware of that. So keeping that open line of communication, and when you want to do something new, making sure that you ask for it and get consent in a clear and documented way. That doesn't mean you have to get someone to sign a form. You can just get verbal consent, but if you do rely on verbal consent, make a note of what you got, when you got it, and how, so that if there is a complaint or a dispute later on, you've got a record of that. Obviously, if there's a family violence matter, that's covered under the Residential Tenancies Act, but you need to have a process to manage any withdrawals in relation to that. And if you are using technology systems to manage personal information, the expectation from the Office of the Privacy Commissioner is that you should complete a privacy impact assessment, which is a structured risk assessment process around the use of that system, what information you're storing in, and how it's being managed. We can definitely help with that, but there is also free guidance on the Office of the Privacy Commissioner's website if you want to undertake a privacy impact assessment, including some sort of training material and templates there. And the other really important piece, which is where we're seeing a lot of people or organizations getting tripped up at the moment, is around the third parties that you work with. And that could be your software vendor, it could be tradespeople, other service providers that you're using. If you're using a third party, you should make sure that they have the ability to manage the information in a way that's suitable and acceptable to your standards. Because a lot of the breaches that we are seeing these days is from a third party, but the organization, so in this instance, the property management company, who's the front facing, are the ones who are ultimately accountable for any errors in that space. So making sure that you're doing your due diligence and not putting your organization at risk. So if you wanted to go back and say, okay, well, what are the things that we really need to have, or an internal checklist for what you have? Here's probably the key things. So you need to have a privacy officer appointed, and that needs to be clearly documented who that is, ideally in their job description. For those of you who are saying, oh, I didn't know that we had to do that, that's actually been a legal requirement in New Zealand since 1993. So if the commissioner comes in and says, who's your privacy officer, and you say, we're not sure, or we didn't know we had to have one, their tolerance for that will be pretty low, given that you've had 30 years to get one in place. Having a clear external privacy policy, up to date and accessible, is really important. And I think really the accessible piece there. So thinking about, say, when you're doing viewings or those sorts of things, do you want to have a copy of the privacy policy along with the application form so that people can see it when they need to see it? If the mystery shopper comes in from the Office of the Privacy Commissioner and you've got a copy of the privacy policy there for people to look at when they're doing that initial viewing, that'll be a big tick in the box of, hey, you're doing things the right way. So relatively easy thing to do, but can make a big difference in terms of that, the view from the regulator. Along with your external privacy policy, which is just telling people, what you do with the information you collect about them, you should have an internal privacy policy that staff understand, which covers things like, what to do in the event of a breach, how you manage information, what your expectations of staff are, rules around, what they can and can't do in terms of taking documentation home, for example. And then alongside that, making sure that your application forms are compliant and only collecting what's needed. So, for those of you who use technology platforms like Renti, that's the work's been done in terms of the design of those forms. But if you are using other forms or other paper-based forms, just make sure you're only collecting what you should be. One of the other areas, and I know Joe's going to touch on this because she talks about it every time we do one of these, is records management processes in place. So again, you should only be keeping information for as long as you need it for the lawful purpose that you collected it. And I know from the work that we've done and from discussions I've had with Joe and others, that's not very well done in the property management sector. Lots of you will have lots of paper records going back many years that you probably don't have any lawful reason to hold anymore. So having a records management process in place, which says these are the types of records that we have, here's where we have a legal obligation to hold it under either the Residential Tenancies Act or for tax requirements or others. And then for the other pieces, this is how long we're going to hold it before we get rid of it. Supporting processes in areas of high risk. So obviously, around, how do you securely transfer information? How do you manage it when you are deleting it so that you delete it in the right way rather than putting it in the curbside recycling and having it potentially blow down the street? And the other piece is really having some level of monitoring and ongoing validation to say, okay, well, for this checklist, we've got it, that's great, we've gone through, said that we've got everything. How do we review that every 3, 6, 12 months to make sure that we are doing the right things, that our staff are complying with the requirements, and are doing the right thing so that if there is an audit or a mystery shopper visit, we're not going to get caught out. And so one of the other areas that the compliance information from the Office of the Privacy Commissioner makes clear is some things that they say are just no-go zones, where if you are asking for them again, these will be things that'll go up on the radar as, hey, we might need to have a bit more of a look here. So you should never collect information that's protected under the Human Rights Act, so sex, relationship, or family status, political or religious beliefs, etc. You shouldn't be collecting whether the tenants have experienced or are experiencing family violence as part of your kind of application process. I have heard of some tenancy managers or landlords actually asking that as part of the screening process, which again gets very awkward very quickly. So again, if your tenant tells you about it, that's a different thing, but you shouldn't be asking for it proactively. Definitely don't ask for copies of bank statements and things. I think the case around sort of getting copies of bank statements and telling the tenant that they'd spent too much on KFC to be able to afford their rent was part of the rationale for the commissioner actually putting out this compliance strategy in the first place. So just don't go there. It's just taking a whole heap of information that you don't need, or that might be interesting but is not something that you can actually compel or require people to provide. Employment history is another one where they say, well, it doesn't actually matter what people's past employment was. You can ask whether they have an income and how they're going to be able to support paying their rent. That's fine, but don't ask for a full copy of their last 3 employers and that sort of thing. And the other area, which is pretty sort of murky and probably a no-go zone, is in the social media space. So don't ask for their social media profiles and that sort of thing, so you can go through and snoop through them and review it. Again, that's kind of a no-go zone from the commissioner's perspective. And so touched on having monitoring processes in place before. I guess, again, what you should have internal reporting places for are privacy incidents. So you should have a record of any breaches or issues or complaints that have come up. So you can look back at them over time and say, hey, is there something that we're constantly making a mistake on here that we need to fix? Are we constantly having emails sent to the wrong person? Are we constantly having complaints about collection? So that you can use that analysis to then inform how you do things better. Keep a record of those access and correction requests as well, because there's quite a legislative framework under the Privacy Act for how those need to be managed. And it's one of the areas where if you get it wrong is typically the biggest cost in terms of any complaints to the Office of the Privacy Commissioner in terms of settlement requirements. So there's some guidance on the Privacy Commissioner's website around that. Obviously, there's organisations like us that can help with that too, but that is one area where it's really important to get it right. Make sure your staff are trained. Again, the Privacy Commissioner has free privacy training on their website, or there's others around, and obviously, webinars like this, making sure that people have the opportunity to see them so that they can upskill and understand what the requirements are, and just do those spot checks. So, develop that checklist, get what you would require in relation to it, and then, make sure that that is done regularly so that you do know both for your own employees, as well as the third parties you work with, that the right checks and balances are in place to manage that. And I reached out to the Office of the Privacy Commissioner just to understand, what are the observations that they're seeing coming through in terms of their activities at the moment under the strategy. And what I got back from them is that they are doing mystery shopper visits. They're doing them randomly across the country, so you won't know when it could actually happen. From the visits that they have done and from the investigations that they've done around complaints, most property managers they've spoken to couldn't explain the rules around what they should be doing or how when they were asked, and either said that they didn't know or said, "Oh, I'm not really sure, but there's probably something on our website. You can have a look there." Which, again, from a regulator's perspective, is not the answer that they want to hear. Some property managers said, "Well, we know we can't require information, but we have it on our forms in case people want to give it to us anyway." And I guess that's a bit of a hot button thing for them around things like bank statements, for example, because again, it's kind of that, you're in a position where the imbalance of power is in the property manager's favor. And so having it on the form, even if it's not mandatory, still makes people feel pressured that they have to disclose it when they actually shouldn't have to. So that's another area where, again, really looking at what you're collecting, how you're collecting it, and those sorts of things. And then examples of over collection they've given, bank statements, asking for full copies of loans that they have and repayments that are coming up for loans, asking for full details of any vehicles that are going to be on the property. Again, not information that's relevant in terms of determining whether someone's an appropriate tenant or not. And the other one, which I guess they called out quite clearly, was around references or contacting referees. So there was a couple of things there. Some property managers were asking for up to 7 references for a tenant. Now, that's pretty excessive. I think if you've got a couple, then you're probably not going to get much additional out of the extra 5, including they were asking for your current employer and your previous employer and your previous or current landlord and a character reference and a family member. And so it just became, overbearing. Or the other thing they were doing was using the reference checking process as a screening tool. So asking for referees at the start of the application process, whereas you should only actually be going out to the referee checking process when you've got to the point where someone's a preferred applicant. And so that's kind of just some key observations, some key things you need to be mindful of. I've got some questions here which we've kind of, pulled together in terms of both Drake, Joe, and I around common things that are coming through. So I thought we'll just touch on those, and I'll start sort of with an answer, and then Joe, Drake, feel free to jump in if you do have any sort of additional things to add around it. So the first one that we've been asked and comes up from time to time is, can we ask for proof of visa length in relation to fixed term tenancy? Short answer for that is yes, because it's relevant to, is someone actually legally able to enter into this contract, because do they have a legal right to be here for the duration of the tenancy? Yes, you can ask for it. You can ask to cite it. I would definitely advise against trying to take photocopies of passports or identity documentation or visas. Again, once you've cited it, you can make a note of it, make a note of when the visa expires. You don't actually need the actual physical copy of it after that. So again, just make sure that you are only collecting the information that you need for the purpose that you need it. Joe or Drake, anything to touch on or add in terms of that area?
No.
Cool.
No, I think that the big thing that I've noticed is the shift from taking copies of things to actually recording the process that you've undertaken to check it.
Yeah.
And
absolutely.
for us to get our head around that.
Yeah. And it's a really important one in relation to particularly identity documents, because if you look at, say, the Latitude Financial Services breach that's been in the media, and they do have obligations in financial services to collect identity documentation for anti-money laundering purposes. But they had a whole heap of stuff that they kept for far longer than they ever needed it for, and then it ended up, affecting over 1 million people in New Zealand alone and over 10 million people in Australia, and had to fork out hundreds and hundreds of thousands of dollars for replacement passports and driver's licenses for people, as well as the stress and harm associated with it. So again, identity documentation in terms of, driver's license, passport, firearms license, all of the under 18 or 18 plus card, sorry, all of those things, again, cite it, confirm you've cited it, and those sorts of things. Don't take a copy and store it, because you're just exposing yourself to a greater level of risk and harm if something goes wrong and it gets breached. The next one, doesn't owner have the right to know a tenant's surname when a new tenant leases their property? It's kind of an interesting one. So technically, as a property manager, you are an agent for the owner of the property and you're acting on behalf of them. So through that, they should have some level of right to access the information. But that's also sort of aligned with, your role as the property manager is, they should be dealing with you, not the owner. So they have some level of protection there. And also, I guess, their expectations around knowing what will be shared. So you would have to understand what is the purpose the owner wants to know that for, and is that therefore a legitimate purpose, not just because they're curious or they want to find them on social media and have a snoop and see what they're like. And generally speaking, going through that process around, okay, well, are they asking for it for a legitimate purpose? If so, yes, you can provide it, but you also should be making that transparent and clear to the tenant. So either getting in touch with the tenant and saying, hey, I've been asked by the owner to provide them with this information. Do you have any objections? And if so, why? So you can balance that and make an informed decision around it. Or making it clear on your application forms and other things, these particular pieces of information may or will be shared with the owner of the property so that they can then have that conversation before the tenancy starts and you can help explain to them what may be shared, why, and under what circumstances. Joe, Drake, anything to add there?
I think, yeah, for me, definitely in terms of educating our owners of properties that we're working for, because a lot of them don't understand about the Privacy Act and just think they can get a copy of every single thing relating to the tenancy. I think we've got some work to do on our side, just explaining to them about our obligations and where they fit with that. And I think your comments about making sure you cover off in your application form that potentially, there may be a request to share their information. And I think also looking at your management authority with the owner, and I think having something in there around the Privacy Act and limitations on information sharing and that type of thing, just so everyone is aware, because I know a lot of people just can't understand why you can't send them everything.
Yeah, I love that. And I think, so just to cover off on what Renti does have a part of the application that does say that your information may be shared with the landlord in certain circumstances. But I love that you brought up, Paul, that, feel free to just give that tenant or applicant, depending on when it is, a call and just say, hey, the owner's requested to know this, this, and this. Are you okay with that? Because I think one of the key points of privacy, right, is no one should ever be surprised at how you're using their information, right?
Completely.
And if you can completely mitigate that by letting someone know or giving them just a quick call, you're always going to be on the right side, or more than likely going to be on the right side of everyone involved.
Absolutely. And that surprise piece is the real sort of key one in terms of, I guess, what we see. When there's a complaint, it's because something's happened that someone didn't expect. Because people don't go around, and I'm sure most of you watching this today don't go around constantly thinking and stressing about what's happening with your information and who's got it and are they doing the right thing, or you'd be just a nervous wreck sitting in a ball in the corner probably. So people don't think about it. People just assume the right things will be done. And it's when there's a surprise or something goes wrong, that's when they get really upset. And just to touch on Joe's point as well around communicating clear expectations with the owner of the property. So, in terms of your agreements with the owner, having that documented in terms of, we will, what you will provide and what they have a right to access and not, is probably quite useful, or having some sort of information sheet for owners as part of them coming on board with you as a client. Clearly outlining, what you will and won't share with them in relation to the tenants as part of that process could be quite useful too. Next question, what are we allowed to ask for as proof of income? So obviously, as stated before, not bank statements, don't go there at all. Payslip, fine. Letter from the employer, fine. Employment contract, okay. I would say if you're looking for, if you want employment contract as proof of income, cite it, note it, don't take a copy of it. Pay slips, probably okay to take a copy of if they're providing it in that way, or if it's a signed letter from the employer confirming their, their salary, etc., their employment status, fine to keep that on file as well. If a lawyer approaches, yeah, go for it.
Sorry, Paul. Just on this one as well. So the way we have built this part of the platform with the Privacy Commission is leaving it completely open-ended. So we have done a really good job of essentially letting the tenant prove to you that they will be able to service the rental payments. And if for whatever reason at the end of that you don't feel like you have enough information on them being able to service those rental payments, you can just tell them, hey, I just need some more information on how you're going to be able to service these rental payments. And they can actually securely go into Renti and upload another document or give you a reference that you can call. I think if you can stay away from leading questions or basically asking outright, this is the document I want, you'll probably be, I guess, a little bit more clear or in the clear for this type of question. And I know this type of question is one of those ones that I think does trip people up a bit, because they were allowed to ask a few of these documents before, and now it's kind of a little bit of a murky area. But I guess the idea from my perspective is really just allowing the tenant to upload what they want and not trying to demand a specific document.
Yep. And again, it goes back to that purpose piece of, the purpose is to try and confirm that they're able to afford to pay the rent for the tenancy, not to understand what their full financial position is and what else they may get up to. So, Joe, anything to add on that one?
I'm interested in your thoughts on this, Paul. Every now and then, and I think more lately I've had this, where you have someone apply for a property that's never rented before. So for whatever reason, they've sold their house, they're new to the country. And they say, what do you need? Because they don't know kind of how to address it. They don't have anything standard. What do you think would be, I mean, I've said to people, I'm not sure if it's right, even just a letter from your bank manager to say that you have the capacity to pay the rent. Because they don't want to share everything, but, they don't necessarily, some of them don't work. They don't need to, but they can pay the rent for the next 10 years.
Absolutely. And I think it is that, having sort of, what you would typically ask for, but then having the flexibility in your process to cater to those other circumstances. And, so someone who hasn't rented in New Zealand before, it's just like someone who's just come out of high school and never had a job before. If you're looking to employ someone as a new hire, you understand that they don't have necessarily that level of references. That doesn't exclude them from it, but how can you, get other information from them to determine whether they're, appropriate to bring on board. So, but doing it in a way where you're having the conversations and you're explaining it clearly to them, rather than just going back and saying, I need XYZ now.
Right.
So the next one, if a lawyer approaches the property manager on behalf of their client, the owner, and asks for copies of the tenancy application or agreement, should you agree? So again, the lawyer in this instance has the same rights as the client if they are acting on behalf of their client, because they're making that request on behalf of the client, so on behalf of the owner. So give the lawyer and respond to the lawyer in the way that you would respond to the owner. If you're not clear or you're not comfortable, then try and clarify what they want and why they want it. And if you're not certain or you're not getting clarity from the lawyer around it, then pick up the phone, have a conversation with the owner, with your customer, and just say, hey, look, I've got this request from your lawyer. We're not sure that we can provide this in this instance because we don't know that the circumstances are fit. So again, just going through there and just making sure that you are doing the right way. But if someone is acting on behalf of the owner, like a lawyer or an accountant, again, treat them with the same rights as you would the owner individually.
Yeah, and I think, Paul, thinking about that too, often we might get a call from the police and they might want us to release some information about one of our tenants. And, it's very easy to slip into that. It's the police. They're the law. I have to do it. But I think we need to take that big step back and ask them to put in writing why they need that.
Definitely with the police.
They might have a legal order or something, and then that's fine. But we need to just pause and not hand all that out straight away because we hear it's the police.
Completely. Asking and clarifying under what grounds are they requesting it? Are they using their information gathering powers under the Policing Act? or equivalent to compel the information, getting them to put that down in writing so you have a record of it, and then making sure you make really clear notes of, we have provided this to X on this date on this basis, so that it is there. Because often when an officer is just investigating a matter, they may not be compelling, they may be just calling to see, do you have any information? And if you have information and you go, and you can just have it all now, then potentially you are breaching privacy because it hasn't been compelled at that stage under their powers. You have chosen to proactively disclose, which puts the risk back on you. So obviously you don't want to be obstructive with the police or anything, and you want to make sure that they're able to do their important duties, but just making sure that you're clarifying exactly, what are they requesting, under what grounds, and do you have to comply or can you choose to comply? And then having that recorded so that if there is a complaint or investigation later on, you've got records that you can refer back to.
And I think too, that's where the importance of having policies around this within your company, so that everyone knows the rules if these situations come up. And I know when new people join, often they get missed out with some of the detail around things like this. So, having some sort of document that they can reference is just invaluable in those situations.
Yeah, completely. And particularly for younger new employees. Because people who are experienced often will have had some level of training or awareness from other roles or other organizations they've worked with, but particularly for those who are just starting out in their careers, most of them probably have never thought about the Privacy Act once in their life.
Yep.
So helping them to understand why it's important is really key.
Yeah.
How do I manage if a tenant asks for a copy of their personal information? So this is a really important one to have a process for and get right. So under the Privacy Act, everyone has a right to ask for what information you hold about them and ask for a copy of it if they want to. If you talk to the Office of the Privacy Commissioner, it's kind of the foundational right, which goes back to my comment around privacy being all about individuals having some level of agency over who has what information. So you do need to have a process for it. It can be a little bit complicated, so definitely it's an area where you could get external support to help you. But generally speaking, the key requirements are, yes, you have to provide it. There are some things that you can withhold, but the grounds to do that are limited and have a reasonably high threshold. So if you've happened to make a note on the individual's file or sent an email about them which says something inappropriate or insulting about them, which does happen, it being embarrassing or making them unhappy is not a ground to withhold it. So you're going to have to release it. So the other, corollary to this is make sure all of your people know never to put down anything in writing that they wouldn't be happy with the subject of that writing, getting a copy of it. Because Murphy's Law is the one time that you've done it in frustration is the one time that they'll probably be disputing with you and they'll make a request and you have to give it to them along with a big apology letter. The other thing to be mindful of is it is time limited. So the individual can make a request in any way. They don't have to put it in writing. So it could be a verbal request, it could be something sent through Facebook Messenger, or it could be a detailed email. All of those have the same, rules around them and the same legitimate sort of nature in terms of a request. And once you've received that request, you have to give the information to them as soon as practically possible and no later than 20 working days. So the 20 working days is not a target, it's a limit. So having the ability for your property managers to know, actually, that is a request for information. We're going to have to comply. I need to flag it up as soon as possible so we can get onto it is really important. Yeah. Joe, Drake, anything to add in that space?
No.
We get requests all the time from tenants or applicants looking for their personal information, and it's something that we have a documented process on. It's something that is kind of almost BAU for us. And I guess just to follow on from your comment on not writing things that you wouldn't be happy to share. I think the biggest or the most common place for that is actually notes at a viewing. So just be mindful about what you write down in your viewing app about the viewers, because that's a charged situation. They desperately want the property, and they will no doubt want to find out, or some of them will no doubt want to find out why they didn't get it. So it's certainly something to keep in mind when you're at your viewing. Maybe just only write down the positives, or write down any sort of red flags in an appropriate way.
Absolutely. Yeah.
Yeah.
It's one that we see people trip up on all the time in all industries, not just in property management. And yeah, particularly sort of for younger and more inexperienced employees as well. They haven't necessarily learnt the implications of that yet. So making sure everyone understands it and is aware of it. Next question, can I keep a copy of photo identification just in case it's needed for debt collection? Just in case is not a legitimate purpose for collecting information under the Privacy Act. So just in case wouldn't cut it. Again, from a debt collection perspective, they don't need a copy of the photo ID to be able to undertake debt collection activities. They do need accurate information about the individual in terms of what you have on file. So recording the tenant's name, date of birth, address, those other things, absolutely fine. If you wanted to have a record of, say, the driver's license number or something along those lines, I would avoid, definitely don't take a copy, but you could do, like sort of, the banks and some online payment things, just record the last 3 digits of the driver's license number if you want to have something that you can hold as a more accurate reference, or the last 3 digits of the passport number, or the expiry date of it, or something along those lines, because that could be used by them as a validation point because they have access to that information to verify against, but you're not at risk of, if you do have a breach or if it goes to the wrong person, having released their actual full identity information. So yeah, thinking about ways to achieve the same purpose without collecting that really sensitive document. And yeah, Jo, go for it.
Sorry, Paul, just a question. Have you got any idea how long it takes to sort everything out if your passport does get taken and your identity used by another person? Passport and driver's license?
So it's interesting and different on both. So passport, typically you can cancel your passport with DIA and ask for a new one. Yeah, hopefully it would never happen when you've got someone who's about to travel internationally very quickly, because that could cause other issues. But generally speaking, standard passport application process, a couple of weeks. If you do have a breach where you have compromised some of that information, I guess the expectation from the Commissioner is you will assist people with that. So there are services out there, like one's called ID Care, that if there is a breach, then you pay them to help manage that process for them, or otherwise you have to provide that documentation and that information clearly to the affected individual around how they do it. Driver's license is a slightly trickier one, because your driver's license number doesn't actually change. The version number changes, but if you want to actually change your driver's license number, there's a whole convoluted process that you have to go through with Waka Kotahi to be able to do that. So while it's not quite as sensitive a type of identity document as passport is, it can actually be harder and more impactful if it is breached in order to be able to get that changed. The other really important thing is if you do have any instances where you have a breach of information that relates to identity documentation, doing 2 things. One, obviously notifying the individuals as quickly as possible around that. 2, letting the individuals know to get in touch with the credit reporting agencies to get a hold put on them, because that's where we see things happen pretty quickly, is if there is a worst case scenario, a cyber hack or something along those lines. You do see the criminals then trying to set up bank accounts and other things in the individual's names using that. So having a credit hold put on there so that that can't be used will stop or reduce that risk around it. So again, and touched on needing to have a process around how you manage a privacy breach before. Having clear understanding, okay, we need to do these things quickly, because if you tell someone within the first day or 2, they probably have a chance to take action and secure it. If you tell them 2 weeks later, the criminals have probably already done something which could affect them for a long time.
Yep.
So yeah, really, really important to make sure that you do that in the right way.
Yep.
And last question that we have sort of in terms of the pre-submitted ones, can I share the tenancy agreement with an owner? Again, it goes back to that, what's the purpose that they want it for? So just because they want to see it? No. They need to provide a copy of the tenancy agreement to their insurance company for their insurance policy. Yeah, that's fine. But again, as I touched on before, let the tenant know that that's going to happen, and let them know why. and make sure that the landlord or the owner is very clear, or you communicate with them clearly around, we're providing it to you for this purpose. Don't use it for any other purposes because it's only being shared for this purpose. So making sure that you're covering your bases on there and educating the owner around that as well.
I think the other thing is us understanding with insurance policies what the insurance company requires, because some have a format for vetting tenants that if there is a claim down the track, they're going to want to see that information, but they're not all the same. So I think putting it back on the owner and asking, what does your insurance company require in terms of our tenant selection, so that you can understand what could potentially be asked for. And then I guess that comes back to your application and just, making people aware.
Yeah, absolutely. And the insurance industry, just as a generality, are well known for wanting to collect everything just in case. That doesn't mean they actually have the right to get it, or that it is mandatory to provide it. So again, if you're not sure, obviously reaching out and getting advice or support around it is definitely a sensible approach to take. And feel free to challenge them and ask them why. Why do you need a copy of the tenancy agreement? I'm a property manager. I'm saying that it is a standard tenancy agreement and it is valid for this period, and we've done due diligence. They don't necessarily need to see copies of all of that because you're attesting to that in your professional capacity. So feel free to challenge those types of requests rather than just sending the information, because 9 times out of 10 they probably don't actually need the document, and something else will suffice. And you're then protecting, I guess, both your own selves in terms of potential breach of privacy, as well as the tenants who you're working with.
And that comes back to you talking about, Paul, recording that process. So your response in that case would be, look, I can confirm we checked references, we did a credit check on this day, and they were sufficient, so that you can give them dates, what happened and the outcome, but nothing else.
Yep, absolutely.
Yep, okay, great. I've actually got an interesting one I wanted to get your thoughts on, Paul. In a lot of small towns, a lot of property managers know each other. And we did have something come through actually at REINZ where a property manager potentially was going to be taken to the Privacy Commission, breach of privacy, because 2 property managers went off and had a cup of coffee and discussed the tenant. And the tenant found out. So nothing in writing, a conversation, but of course, I think making people aware too that you can breach privacy that way.
Completely, because again, you're sharing information that you didn't have a purpose to, and information is information in your head as well. So it's not just the the written documents. The Privacy Act covers everything that you hold or are aware of about an individual. So I think definitely being really careful about those things, only sharing information if there's a legitimate purpose to, and you've got the right, I guess, permission or consent to do it. It's the same as an employment situation where companies in a similar industry, someone's applied for a job there, they reach out to, hey, have you dealt with this person before? What do you think about them? That's actually not okay, because there is a process for the individual to provide references, and that's who you should be collecting information from about them. So definitely making sure that you're only doing the right thing in that way is key.
Right.
That's a great example. And I think that's one of those ones that, like we touched on before, the industry is so tight knit, there'll be a lot of property managers going for coffee and talking about things. So just, being careful on what information you're sharing.
Yeah, absolutely. And even if you move from one property management agency to another, and come across one of your past tenants, for example, who may have not been the best tenant, being really careful about what you would document or what you would sort of, formally record about them, because again, if you're no longer working for that previous property management agency, then, the information hasn't been collected for the purpose of your new activities, and you could get, again, in trouble if you start writing information about them in the new organization.
Yeah, fabulous. I think that just about covers it. I think there was a lot of really, really good points in there and a lot of good takeaways. Certainly demystifying the difference between the Privacy Act and the Residential Tenancies Act and which one takes precedent, but also just common sense, right? You're using people's private information, you're holding people's private information, and no one should be ever surprised about the way that you use it or where you share it.
Yep, absolutely. And if you aren't sure, then there are lots of avenues where you can get the support. So obviously organizations like mine can help. Joe and the team at REINZ are great for getting, advice and support. The Office of the Privacy Commissioner's website has lots of documentation on there, and they've also got an inquiry line. So you can just pick up the phone and ring them and say, hey, we're dealing with this particular matter. What should I or shouldn't I do? And they will provide some advice and support as well around that. And again, just keeping records of what you're doing and why when you're making these decisions is the most important thing, because if there is a complaint or a dispute later on, then it's not a he said, she said, or I'm trying to remember what happened. You've actually got the record from the time when it occurred, so you can point back to that.
I think too, Drake, one of the biggest challenges that our officers face is, like you say, historically we had paper copies of everything. And I know that in the last 5 years, maybe more, a lot of people have made a real effort to go paperless. But there's some people that just do not know where to start, and they have boxes of information they do not need everywhere, and they are holding on to it saying, oh, I'm just worried in case I end up at the tribunal. I would challenge property managers that are in that space to remember, when was the last time 5 years after a tenancy ended you got taken to the tribunal? Because I can tell you in the last 29 years that has never happened to me, and I've managed thousands of properties. So you've got to be realistic. And I know that Paul talked about a document management process for what are you going to do with these things 12 months after the tenancy's ended. Now, I know that, Paul, they offer a great service helping people do that, because that takes some time to work that out. But once you've got it in play, it's easy. It's a checklist. We don't need this, we need this, but people just don't know where to start. So I would encourage you, if you are that office, and there's lots of them that haven't really thought about a document management process, and you don't know where to start, you're still not paperless, you've got to start with one box at a time, and you've got to have a process. Yep. So, you just have to get started. The other thing that I know, we have a lot of small 1- and 2-man bands that do property management, and they don't necessarily have the advantage of the big brands where they have their internal and external privacy policies written for them. Paul, is it sufficient to go onto the OPC's website and use their privacy statement generator, or do they need someone like you to write their privacy?
Definitely the Privacy Commissioner's website, as a starting point. So that'll give you, it asks you some questions and then helps, pre-populate a template for you. The only thing I would say with it is, don't take that as, okay, it's gospel and it's right, because again, it's a generic one that is designed to be a starter for all industries, and property management, particularly with Residential Tenancies Act and some of the other dynamics. Important to make sure that you do cover it off in the right way. So definitely use it as a start, but don't just take what it spits out and put it on your website. Read through it, think, does this tell me everything, or tell people everything that's needed? If not, what else would I need to include in here?
Okay. And playing devil's advocate, say you did get rid of a whole lot of documents and things 12 months after the tenancy had ended, and then you do have a situation where you get asked for something, but you've destroyed it. Mm-hmm. Is that a legal position to take, that, hey, we've followed the process?
Completely, and it's exactly the right process to take. So if someone says, I want a copy of all my information, you say, well, actually, sorry, the tenancy expired X number of years ago, we no longer hold that information, then that's a perfectly legitimate reason under the Privacy Act not to provide it, because you can't locate that information. And it's the right thing to do, because again, you're protecting the risk of something going wrong with that information downstream, so you don't end up like a Latitude Financial Services, where people who haven't been your customer for 10 years are having to go and change documentation and everything else because you kept it when you shouldn't have.
Yep. And everyone's clear that we're not talking about financial records here. We know that that's a minimum of 7 years, and everyone's using operating systems that keep all that data anyway. So, that's not a problem. We're talking about actual tenancy, RTA paperwork and stuff like that. So yeah,
absolutely.
Cool. Okay.
Excellent.
Thank you both so much for this. It's been a pleasure. And like I said, I definitely think we've ticked that box of creating a bit of a recording where people will be able to reflect back on this 6, 12, 24 months down the track. I really appreciate you both joining me. As a last comment, Paul, do you want to tell people where they can reach out to you if they need anything privacy related?
Yeah, absolutely. So contact details are all on our website, so infobydesign.co.nz, and you'll be able to reach out to us there, and we can definitely help in any way that you need.
And Joe, people know they can reach you at REINZ.
Yeah, absolutely. They can, you know, we often get asked various questions about things. You know, one of the questions we had not that long ago was about, you know, a lawyer ringing to ask for documents. And I think just if you're a member of REINZ, honestly, reach out. We do have a legal team there. They won't give you specific legal advice, but they will point you in the right direction.
Thank you, guys. Take care.
Okay. Thank you.
Thanks.